Straight ahead on Law and Crime Daily. New charges in the deadly Michigan high school shooting.
Today I'm announcing charges against the shooter's parents, Jennifer and James Crumbley.
And
I don't want them to have to be maimed or potentially die from an illegal abortion.
hear women's right attorney Gloria Allred's take on the Supreme Court abortion case. Plus,
I just held Maureen. Ask God why.
hear firsthand from accused wife killer William Argie, who takes the stand in his own defense. And later, Alec Baldwin's first interview after the deadly Rush shooting.
She goes down. I thought to myself, did she faint? I would go to any lengths to undo what happened.
Why the actor maintains he never pulled the trigger. Law and Crime Daily covering court cases from coast to coast. Welcome everyone to Law and Crime Daily. I'm Brian Buckmeyer along with Terry Austin. The parents of the accused Michigan shooter are charged with involuntary manslaughter. Prosecutors say they gave their 15-year-old son access to the gun and ignored warning signs that he may stage an attack. On Friday, Oakland County Prosecutor Karen McDonald announced Jennifer and James Crumbley will each face 4 counts of involuntary manslaughter, stemming from Tuesday's attack that killed 4 students and injured 8 others. Their son, 15-year-old Ethan Crumbley, is being charged as an adult in the shooting. He's being held without bail on charges of terrorism and first-degree murder. Officials say teachers reported Crumbley drawing disturbing images the day before and the day of the shooting, including weapons, blood, and killing. They say Jennifer Crumbley sent her son a text saying, quote, "LOL, I'm not mad at you. You have to learn not to get caught." The day of the shooting, both parents were called into the school for their son's concerning behavior.
At the meeting, James and Jennifer Crumbley were shown the drawing and were advised that they were required to get their son into counseling within 48 hours. Both James and Jennifer Crumbley failed to ask their son if he had his gun with him or where his gun was located, and failed to inspect his backpack for the presence of the gun, which he had with him. James and Jennifer Crumbley resisted the idea of then leaving the school at that time, of their son leaving the school at that time. Instead, James and Jennifer Crumbley left the high school without their son. He was returned to the classroom. When the news of the active shooter at Oxford High School had been made public, Jennifer Crumbley texted to her son at 1:22 p.m., quote, "Ethan, don't do it," end quote. At 1:37 p.m., James Crumbley called 911, reporting that a gun was missing from his house, and he believed his son may be the shooter.
Joining us today is criminal defense attorney Taylor Koss and Terry Austin. Taylor, what's the prosecution's theory for charging Ethan's parents with involuntary manslaughter, especially considering these text messages, and is it a strong one?
So, thanks for having me, by the way. This is, these are unusual charges in school shootings that occur across America. I don't think we've ever seen charges like this for the parents, but these are unique circumstances. We have Facebook posts of the parents taking the child to buy what they call an early Christmas present, the gun. We have text messages between the parties that are really disturbing. And, we have the son searching for ammunition in class. And when the parents find out, they say, LOL, don't get caught. So this type of behavior is what opened the door to these charges. I'm sure there's more where that came from. And I think in these circumstances, it was the right thing to do.
Yeah, definitely more where these came from. Sorry. Terry, break down this meeting that Ethan had with school administrators and his parents and how prosecutors are saying this tragedy could have been prevented.
Well, absolutely. If you know that there's a problem and you're being told by the school that there's a problem with your son, you are then notified that there is a problem here and you need to do something about it. And instead, what they did was to completely ignore those warnings. They knew that the child had a gun. They sent those text messages, as you and Taylor have both said. And so I definitely think they should be charged. They are culpable, and it will send a message to the rest of the United States, frankly, because that's where we have these types of shootings occurring. But it'll send a message that you are responsible for your actions, and your actions are, when they are affecting your children, you need to do something.
Yeah, it's interesting that Taylor said, and Terry, you tagged on as well. These are unique charges. We don't usually see these types of charges for parents. I think this prosecution will definitely send a message throughout the country. On to Minnesota, where a complete jury is seated in the trial of ex-cop Kim Potter. 12 people make up the jury with 2 alternates. In total, there are 7 men and 7 women. 10 are white, 2 are Asian, and 1 is black. The ethnicity of the last alternate juror has not yet been released. Potter is facing manslaughter charges in the shooting death of Daunte Wright in April of this year. Body cameras caught the entire incident on video. Police were pulling Wright over for an expired registration tag and determined he had an outstanding warrant. When they attempted to take him into custody, police say he resisted. Potter warns Wright that she is going to tase him, but pulls her gun instead and shoots Wright once in the chest. Potter's defense maintains the shooting was an accident. The trial is set to begin on Wednesday, December 8th. On the next episode of Law and Crime Daily, we'll delve into the charges against Potter ahead of opening statements.
I've determined then that an appropriate time to be looking for trial will be in January of 2023. So that will still provide 14 months of preparation time from now going forward.
A trial date is officially set for the so-called doomsday duo accused murderers Chad and Lori Vallow Daybell. The pair faced charges in connection to the death of Chad Daybell's wife, Tammy, who died suddenly in 2019. Daybell refused an autopsy. Just weeks later, he and Lori Vallow Daybell were married. Both are also charged with the murder of her 2 children, Tylee Ryan and JJ Vallow. The bodies of both children were found on Chad Daybell's property in June 2020. The couple was given the nickname Doomsday Duo for their strong end-of-times belief and the string of sudden deaths that surrounded them. On Thursday, a judge adjourned for 2023 trial date for the co-defendants, as Lori Vallow Daybell's competency to stand trial remains up in the air.
No timeline as to when she may be restored to competency. Those are issues that we can talk about privately. And as far as the trial being set either a year or 2 years from now, it does take some time for mitigation, the process with mitigation specialists and investigators. That process has not started yet because of her incompetency, and whether or not she'll waive her right to speedy trial is still an issue that she cannot decide at this point. And so I think the general timelines, yeah, it does take 2 to 3 years to get a death penalty case to trial, if that's what the state is seeking.
The trial is expected to last about 10 weeks, including jury selection. The prosecution says they will seek the death penalty if Daybell is convicted. Still ahead on Law and Crime Daily, an accused murderer takes a stand in his own defense in the trial of William Argie versus New Hampshire. Hear what he said happened in the moments leading up to her death. But first, could Roe v. Wade be overturned by the Supreme Court? Law and Crime's own Terry Austin hears from women's rights attorney Gloria Allred for her take on the controversial topic.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back. Supreme Court Justice is now in deliberation to potentially overturn the famed Roe v. Wade decision. Our own Terry Austin heard from a high-profile activist who explains what the fallout could be from such a monumental change.
Brian, I spoke with women's rights leader Gloria Allred, who says overturning Roe v. Wade could lead to dozens more of the states tightening the restrictions on abortion laws. On Wednesday, justices heard arguments focused on a Mississippi law that bans abortions more than 15 weeks after conception. Supreme Court justices previously ruled states cannot ban abortions before viability or when a fetus can survive outside of the womb. Viability is now considered between 22 and 24 weeks. Mississippi officials say scientific advances allow babies to survive earlier. Gloria Allred tells me Should Roe v. Wade be overturned, many other states would be triggered to overturn abortion laws as well. She told me her own personal story. Her strong convictions on abortion legalization stem from those stories.
This is before Roe v. Wade, and I was a single parent, not earning much money, and I was raped at gunpoint in Mexico. I became pregnant, came back to California. It was a crime for a doctor to provide an abortion in California. At that time, they called it to assist in a miscarriage, is what they called it. And so I had to find a back alley abortionist, not a licensed medical provider like a doctor or a nurse, somebody who would just do it for the money. He did it. I ended up hemorrhaging in a bathtub, being taken by ambulance to a hospital, had 106-degree fever, had to be packed in ice, and almost did not survive from the infection. This is why I'm so committed to Roe v. Wade, that abortion has to be safe, it has to be legal.
Let's bring back criminal defense attorney Taylor Koss and Terry Austin. Terry, what else did Gloria Allred said about SCOTUS's deciding of this case?
One of the things she said to me, Brian, is we have to keep up the fight. We cannot lose this right. It is a personal right. It is a right that we've had for decades, as she said. It's something that if the legislation doesn't do something in the Congress, then we have to get out, we have to protest, we have to fight this battle on all fronts. And believe me, she was very serious about it. You heard her personal story, and so it left me thinking that this is one of those rights that we cannot afford to lose.
Now, Taylor, the Supreme Court could do a number of things, but let's focus on two of those. The court could limit its decision to just the Mississippi law or overturn Roe v. Wade altogether. What do you think it could do in this case?
So I think, the Mississippi law in between is dead. I think it's finished. I think they have that's in their sights and it's done. And now it's really a matter of if those last one or two conservative appointed judges on the Supreme Court are willing to go to the distance. Clarence Thomas has been waiting for an opportunity like this. Some of the others have as well. And so the question really is, are they going to keep it to just, the local law, which I think is already a done decision, or are they going to expand it? And I think, this is an important fight. It leaves our country in a very difficult position. And, Hillary Clinton actually had a very interesting tweet the other day, which said, we cannot leave our grandchildren with less rights and privileges than we ourselves had. And that's the situation we're putting them in right now.
That's an interesting quote nonetheless, and especially since this landmark case has been around since '73 going forward. The question is, what rights will men and women, especially women of this country, have with the autonomy of their body going forward? Thank you both. Up the coast in New York, Friday marks the end of the week in the federal trial of Ghislaine Maxwell. Maxwell faces a slew of charges for sex trafficking for allegedly helping Epstein groom young teenage girls for sexual abuse. Maxwell has pled not guilty to all charges, as her defense argues she's a scapegoat for Jeffrey Epstein, her longtime companion. In court on Friday, the defense started the day with cross-examination of Juan Alessi, the man who ran Epstein's Palm Beach home for more than a decade. Much of Friday afternoon's testimony was visual, including content not available to the press or public. Prosecutors later called crime scene investigator Gregory Parkinson to walk through videos and photos of Epstein's home. The exhibits, including a photo prosecutors described as sexualized image of a young girl displayed outside Epstein's bedroom. Epstein was found dead by suicide 2 years ago, 2 months after his arrest on federal sex trafficking charges. Coming up, William Argie comes to his own defense against charges that he murdered his wife as their children slept. Here is testimony from the New Hampshire courtroom next. Plus, Alec Baldwin speaks out for the first time since a young mother was fatally shot on a movie set. More from his exclusive sit-down interview with ABC News ahead on Law&Crime Daily. Welcome back to Law&Crime Daily. The defense rests his case after accused murderer and defendant William Bill Argie takes the stand. Argie faces life in prison for the murder of his wife, Maureen. Prosecutors say he strangled or suffocated her after saying she wanted a divorce. They say he attempted suicide after killing her, ran off, and gambled at a casino. Argy was also the sole beneficiary of his wife's $400,000 life insurance policy. At the time, the defendant faced a gambling addiction, job loss, and growing debt. The defense argues she killed herself and that Argy found her in bed with a sheet around her neck. On Friday, Argy testified, recounting the morning he says he found his wife dead in their bedroom.
I saw my wife with a bed sheet around her neck. And jammed between her nightstand and her in the bed.
On cross-examination, the prosecution pushed Argy to reveal what he did with his wife's cell phone after she died.
When driving, I got frustrated that I would not continue to have the phone, and I threw it out on 395.
Phone went dead and you threw it out, right? Tossed it away. Abandoned it. Right?
Correct.
Just like you abandoned your dead wife. Right?
I did not abandon my dead wife.
You did not abandon your dead wife.
Here with us is criminal defense attorney Taylor Koss and co-host Terry Austin. Terry, with so much circumstantial evidence against him, how was Argy's direct examination?
I thought it was terrible, really. I mean, he said the right words. There's no question about it. It was clear that he had been well prepared by his attorney, but it seemed so fake. It seemed so staged. He had an excuse for everything, and the excuses really didn't make sense. He, for instance, put the bed sheet in the bag when he left after killing her. So why did he bring the bed sheet? It just doesn't make sense to me.
I mean, Taylor, usually when the defendant takes the stand, the direct examination is the easy part. So let's ask him about the hard part. Is there anything Argy could have said that would have led to a not guilty? And how do you think he held up on cross-examination?
I mean, sometimes people are just not meant for this. And you look at the way he testified and his mannerisms and the way he was communicating. And it's a terrible thing to say, but he just looked guilty and he acted guilty. His answers were not strong. They were not focused. Not to mention the evidence is fairly strong against him. So, he was in a bad position and he did not help himself.
Yeah, I mean, hindsight is 20/20. We'll obviously find out when the verdict comes in. But the question here, I think that people are going to be asking themselves until that verdict comes in is, should William Argie have taken the stand? Or maybe he should have just remained silent. Of course, that's his decision. That's his right. Nothing that any lawyer can tell him otherwise. But of course, we'll see when that verdict comes in. When we come back, Alec Baldwin's first interview since the fatal shooting on the set of his latest movie. Why the actor says he never pulled the trigger and calls the victim a friend. All that still ahead. Welcome back to Law and Crime Daily. We're hearing from Alec Baldwin for the first time since the deadly shooting on the set of his latest movie. In an exclusive interview with ABC, the actor says he never pulled the trigger.
Well, the trigger wasn't pulled. I didn't pull the trigger.
So you never pulled the trigger?
No. I would never point a gun at anyone and pull a trigger at them, never.
On October 21st, 42-year-old Helena Hutchins was killed and director Joel Souza was injured when Baldwin fired a weapon with a live round on the New Mexico movie set of Rust. Baldwin says he believed the gun did not have any live rounds in it and that he never pulled the trigger. Since the shooting, multiple lawsuits have been filed against Baldwin and other producers, as several crew members claim emotional distress and deliberate infliction of harm. In his first interview since the deadly shooting, the 63-year-old actor sat down with ABC's George Stephanopoulos. He calls Helena Hutchins a friend.
That her work was beautiful. She was someone who was loved by everyone who worked with and liked by everyone who worked with and admired. Sorry. But admired by everybody who worked with her.
Taylor, as a criminal defense attorney, Alec Baldwin, a man who could potentially face criminal and civil charges, did his explanation in this interview with ABC help him at all?
I think it probably did. The court of public opinion is huge in these matters. It's tough to get individual liability on things like this. And so, you know, the narrative that was building up, especially with all these lawsuits coming from other members of the crew and stuff, was that essentially that Baldwin took a gun, pointed at someone, pulled the trigger, and you know, callously murdered them. You know, didn't mean to have a live round in there. But so to get out there that that narrative is not accurate and to put his own touch on it, to show the emotion and feeling behind it, I think it probably did help him.
Yeah, absolutely. I mean, yes, the people are going to say he's an actor. He can turn on the waterworks and turn it off, but I think it is going to help him to some degree. Talking about some of the people in the background and some of the stage individuals, Terry, Mr. Looper, a cameraman, had many, as it appears, safety complaints, and even walked off the set with a number of other camera people. But the argument is he's just a cameraman and didn't deal with any of the safety issues on set. So how's Looper's opinion going to affect any potential charges?
Oh, his opinion is definitely going to affect the civil lawsuits. No question about it. We know already that there are at least 2 civil lawsuits. One of them was actually brought by the chief lighting individual. He too has nothing to do with safety, but he brought a suit claiming that there was negligence on that set. And the other second suit that we know about also is claiming negligence. So it really doesn't matter. You don't have to be a safety expert to understand and realize and recognize the fact that there is something wrong on the set and they need to do more.
Yeah. Don't forget that it's not just a potential of murder charges. There's manslaughter charges. There's criminal negligent homicide. There's reckless homicide. So when it comes down to the level of intent, or mens rea, as lawyers will call it, it's still up in the air as to what Alec Baldwin could be facing. And as Taylor and Terry has said, many statements can lend to that. Well, thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.